He's lived with one girlfriend, and then once they broke up, he lived with another girlfriend. There has been a significant change in circumstances on both parties' side that would prompt a review of the current custody order by this court. The minor in question here is Grayson Cromwell. He is 12 years old. The parties share one minor child. Since the entry of the 2019 order, defendant father, who has sole care and custody currently of the child, has not been able to provide stable housing for the child. There's been a change of the custodial environment affecting the child, and modification of the current custody order would be in the child's best interest. Defendant has failed to provide stable living environment for the minor. He has been living with girlfriends since the 2019 custody order. He's lived with one girlfriend, and then once they broke up, he lived with another girlfriend. And then earlier this year informed that girlfriend that he was homeless. Defendant has not been able to secure his own housing or sleeping arrangements for the child. The child does sleep in the basement with no egress window. There was a CPS investigation, and when CPS came, a mattress had been moved to another room of the home for the child to sleep in, but that is not where he primarily sleeps. Defendant has not been actively involved in the child's education. The child at one point in time during last year's school year had 17 missing assignments. He had multiple tardies and absences, and that resulted in 2 failing grades. I do believe he was able to bring those grades up, but the point that he was failing classes and had 17 missing assignments under the care and custody of defendant father. Defendant has also threatened to physically harm the child. During one incident, he did slap the child across the face and kick him out of the house during the winter. The child did not have a coat on during that time, and he was also battling strep throat at the time. Defendant father did call plaintiff mother to come and pick the child up at that time. The defendant has periodically left the child with family members while he's gone out of town. The minor child has not seen defendant father many times over the summer. The minor child was living with the defendant's mother and his grandmother. He had no things of his own. All of his things were being sold off by the defendant father's girlfriend, who is presumed to also have struggling with a drug addiction and drug use. In the meantime, the mother has been able to have the same housing and job for the last 3 years. She is the one that the child looks to primarily for guidance. She is the one that the child opens up to and speaks to about how he's feeling. He looks to the plaintiff mother, for the necessities of life. There was one point in time when defendant father was not able to provide the child with school clothes, and plaintiff mother and her mother purchased this child's school clothes and also shoes for school that were not purchased by defendant father. Defendant mother has recently joined a church. She's been active in her church for the past year. She is not currently in a relationship. She does not have multiple people going in and out of her children's lives. Like defendant father has been in 2 relationships since the custody order and has lived with both girlfriends. The child has expressed his desire to live with plaintiff mother. Plaintiff mother has provided a permanent family and stable home for her youngest son and also for the minor in question here. She does have another child who is 6 years old, who she has provided stable living conditions for, and stable living conditions for when the minor child in question here is in her care and custody. Plaintiff mother has also worked hard to facilitate a relationship between the minor child and also the defendant father. She has never done anything to try and hurt that relationship between the two, but due to the instability of the defendant father and his inability to maintain stable housing, to be an active parent in the role of the minor child, especially at 12 years old, defendant father has not taken him to doctor's appointments or dentist appointments. Plaintiff mother has been the one to take the minor child to doctor's appointments and to sports physicals during the defendant father's parenting time. She was also the one to take and be present at the minor child's open house for school and purchase the necessary binders that he needed for school during defendant father's parenting time. For those reasons, we are requesting that the current custody order be reviewed by this court and that plaintiff mother is awarded sole physical care and custody of the minor child. We are asking for joint legal custody so that the two parents can continue to co-parent and make decisions for the child together, but we are requesting sole physical care and custody of the minor child for plaintiff mother.
Okay, thank you. Miss McNiff?
Your Honor, we believe that this motion was filed as a result of my client filing his motion to change domicile, which referee Bradfield did grant. My client has had stable work, has had stable home. He worked for Art Van for 9 years, and when Art Van went out of business, then it became a bit of a struggle for him to find a new job. He's been offered a new job in Little Rock, Arkansas, that potentially will be much better fit for him than anything that he can find in Michigan. He anticipates that he can make upwards of $80,000 to $100,000 a year working for this furniture store in Little Rock. He has extended family in Little Rock, including a brother and other family members. So he believes that this move to Little Rock will be very beneficial both for himself and for the party's minor child. The fact that the allegation that my client has been homeless is absolutely untrue. He was in an argument with a past girlfriend, had some texts, those text messages would be hearsay. No time has he been homeless. He's lived on Territorial Road with his girlfriend for the past 2 years. The minor child shares a bedroom with my client's girlfriend's child, who is the same age. The two boys share that bedroom. In the basement, they have like a playroom with a couch and game consoles and things like that, so that each child has the opportunity to have some space if they want, but they sleep upstairs in a bedroom, which is completely appropriate. My client's girlfriend does not use drugs. She does have depression and she takes medication for that depression, but she does not use illegal drugs. The allegations that she's using illegal drugs come from a woman who has had her children taken away for her use of illegal drugs and is simply not a credible witness whatsoever. My client has not been violent with this child. We believe that there was an allegation by plaintiff this past winter of physical violence. CPS investigated. They did not substantiate. My client advises that he swatted the child on the bottom. The child is 12, and it simply was not a major issue whatsoever. He has left the child this summer with his mother and his grandmother at times while he's been going to Little Rock in order to secure housing for the family and in order to negotiate with his new employer as to the terms of that employment. However, now that he's been granted permission to move to Little Rock, the child will be residing with him completely and won't be staying with his mom or his grandma. The child failed one grade last year. My client is trying to teach him the consequences of his actions. He's been in constant contact with his teachers. He's been working with them. My client's mother and grandmother have also been working with the child. My client's grandmother is a retired teacher and has been tutoring the child. With regard to the tardies, if the child is 1 minute late, he gets a tardy so he can be dropped off at school in time. But if he dawdles and doesn't get to his classroom right on time, he does receive a tardy. However, my client has been on him in order to make sure that he is on school on time. My client has always provided clothing and school supplies for the child. He purchased a backpack and other school supplies for this year. There was a time when Ms. DeLong was purchasing school clothing for the children, but not permitting the child to bring the school clothes back to dad's house. So both parents had clothing at their own homes. This child absolutely wants for absolutely nothing. But the allegations that my client is unstable, that there are drugs in his home, are absolutely false. We don't believe there has been any change in circumstances other than the allowance of my client to move with the child to Little Rock, Arkansas. And we would ask that this motion be denied.
Okay, thank you. Well, what the court's going to do is obviously there's a lot of allegations. And obviously, if the allegations are true and accurate, that it could serve as a basis for a change. I understand the answers. I'll say to you, Ms. Smith, is that based upon what Miss McNiff has stated, if in fact the testimony comes in as she has stated, then court would find that there wouldn't be a basis for a change of custody, but I'm not going to, again, decide that matter on a motion when we haven't been presented evidence. So the court will grant you an evidentiary hearing on this matter, but I would state that if the proofs come in as Miss McNiff has stated, that would in fact refute that, and the court would entertain at that time an assessment of a cost and attorney fees in this particular matter. So you can contact my office. We'll see when the attorneys are available, and we'll set it for an evidentiary hearing and proceed in that manner.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Court will end this matter at 9:18 a.m. You're free to go. Have a good day.